work to improve the quality of our nation's waterways. In our continued pursuit to protect and improve the quality of our nation's waters, it is imperative that the regulatory framework under the Clean Water Act works as Congress intended it to work, allowing the demands of the 21st century to be met. To do so, we must have environmental protection and economic development. This critical balance that protects the environment without unnecessarily hampering our economy and private property rights. To achieve this, we must also balance the role of the federal government with that of the states and municipalities. The Clean Water Act was never envisioned for the federal government to have control over every ditch and mud puddle. It left room for states to protect their waters as they best see fit. So consider this as well. Our competitors in China, as well as elsewhere in the world, they don't care about regulations or environmental permitting. When they want to build it, they just do it, with little, if any, regard to the environment. Now, while we do not want to adopt their mentality, nor would we should not put meaningless delays on critical infrastructure projects like manufacturing, housing, or very critical energy projects. As I've stated many times before, regulations should be simple and easy to follow. The benefit of that is they should carry out the intent of the law in a clear and transparent manner, making them easy to enforce. There should be no subjectivity or wiggle room for any bureaucrat to substitute their own biases or interpretations. But unfortunately, that's certainly not been the case with the Clean Water Act. Now, there is no greater example of bureaucratic overreach than the nightmare complying with and understanding the definition of a water of the United States, or WOTUS as we call it. This definition determines the scope of jurisdictional waters under the Clean Water Act, affecting water quality certification programs, pollutant discharge permits, and oil spill prevention. Now, a good example of all this is in North Carolina. Pharmaceutical company Novo Nordisk, a worldwide leader in treating and preventing a wide range of diseases, including diabetes, announced a $4 billion investment for a site expansion, bringing more than 1,000 jobs to the state. In October, they requested a jurisdictional determination, or JD as we call it, which never came. They were told to apply for a permit to modify it once a JD was issued. They have since applied for a permit without determination. However, the permit review process, can take more than a year. Novo Nordisk cannot conduct on-site avoidance and minimization analysis before they know what parcel of property must be avoided, nor can they conduct an off-site alternatives analysis without a clear concept of how their site works against other sites that may or may not have similar issues. And this is just one example of many instances across the country where economic investment and job creation, and in this case, public health as well, are all stalled due to this vague process. The Supreme Court's ruling in Sackett versus EPA last year provided a decisive win for America's farmers, small businesses, and property owners. Yet despite the court's clarity, there remains a distinct incongruence between the ruling and the latest definition of a WOTUS from this administration, which has led to a new round of legal challenges and additional confusion. When Assistant Secretary of the Army for Civil Works, Michael Connert, testified before the subcommittee last December, he reported a backlog of more than 4,000 jurisdictional determinations that need to be made. While the administration claims some progress has been made in improving these, the inconsistent and piecemeal approach it is taking in implementing its WOTUS rule is causing serious delays on a variety of different projects around the nation. Sackett struck down the significant nexus test and held that a WOTUS must have a continuous surface connection to traditional navigable waters. That ruling was over a year ago, and we just passed the 1-year mark since the administration issued its revised rule. Farmers, home builders, businesses, manufacturers, and many other hardworking Americans rely on the Corps and EPA for predictable, workable, and stable WOTUS regulations. The administration has not yet delivered. So in summation, the administration's implementation is not in accordance with the Sackett ruling generally, nor is it consistent project to project where JDs have been issued. So I remain concerned about the lack of transparency and lack of consistency with which this revised definition has been implemented. We are all still waiting for clear and consistent guidance on which everyone can rely. The decision to approach WOTUS on site-specific basis without clear training and universal application has served only to muddy the waters, no pun intended, of a very clear and straightforward Supreme Court ruling. So I look forward to hearing from our witnesses today about their experiences and challenges with WOTUS implementation since the Sackett decision and what recommendations they have for us in Congress so we can work to provide surety to Americans who rely on clear implementation of this important rule. I now recognize Ranking Member Napolitano for 5 minutes for an opening statement.
Thank you, Mr. Chairman, for yielding time to me. For the past 25 and a half years, I have made protection and preservation of water a primary focus of my time in Congress. In the arid West, where annual droughts have become an unfortunate consequence of warming climate, I have worked to make our communities more resilient to climate change, such as ensuring my communities are prepared for their current and future water needs. I have worked with local officials to promote the conservation, recycling, and reuse of every drop of water available, knowing of these ongoing challenges that may soon face every community in the United States. I grow frustrated with a heated and often misguided rhetoric on the scope of waters protected by the Clean Water Act. In my view, we get lost on questions of who is best suited to protect our water resources, rather than thinking about the importance of rivers, streams, lakes, and wetlands for current and future needs. Mr. Chairman, clean water was not always a partisan issue, and no issue has more support among American families than the protection of the nation's waters. Yet, in recent years, this issue of comprehensive Clean Water Act protections has become so politicized that it may become increasingly difficult to find any commonalities. For this, I cite the example, this issue is prominently highlighted in the Extreme Project 2025 Manifesto. It has been the focus of 2 failed Congressional Review Act efforts to overturn vital clean water protections, and recently, decades-old water protections have fallen to a Supreme Court that time and again substitutes its own conservative philosophies for the established legal precedent or clear statements of our congressional intent. In the aftermath, we're left with a nation less prepared to protect its precious water resources and less capable of ensuring long-term health and resiliency of our communities, our neighbors, and our future generations. History has shown that current state-by-state approach to protecting rivers, streams, and wetlands is likely to fail, as it did before the enactment of Clean Water Act. Without minimum levels of protection, states will negatively be impacted by pollution from upstream sources if neighboring states choose not to put the same priority on protecting water resources. Without minimum levels of protections, farmers, business, and communities may no longer rely on sufficient, safe, and sustainable water supplies of water to meet our quality of life needs, our economic and agricultural needs, and our day-to-day survival, especially in arid regions of the West. Without minimum levels of protection, American families may be forced to pay more for safe and reliable resources of water for their homes, if such resources even remain available. Without minimum standards of protection, businesses will face different requirements and standards in every state or community, likely increasing complexity and cost of doing business, will again result in higher prices for American families. Mr. Chairman, my remaining time in Congress, I remain committed to protecting clean water for more people, not less. I believe the Supreme Court purposely chose to substitute its own philosophy over decades-old legally grounded efforts to protect water quality. That's why I joined the ranking members, Len Larson, Congressman Beyer, and Congresswoman Stansberry in introducing Clean Water Act of 2023. I believe this bill will restore the minimum levels of protection struck down by the conservative court, but can put back into place predictable federal-state partnership which protects our rivers, streams, and wetlands for over 5 decades. all while providing predictability and certainty to American businesses. To me, the answer is clear. We should recognize the familiarity and workability of the historic Clean Water Act and get on with the preservation of the health of our economy as well as that of our communities, of our environment, and our water-dependent futures. Mr. Chairman, I yield back the balance of my time.
Gentlelady yields back. I now recognize Ranking Member Larson for up to 5 minutes.
Thank you, Mr. Chair and Ranking Member Napolitano for this hearing and update on the waters of the U.S. and the Clean Water Act. My home state of Washington is defined by its clean water. From Puget Sound to the hundreds of lakes and thousands of miles of rivers and streams, Washingtonians know that protecting these rivers, streams, and wetlands take work, and that the health of our water bodies are intertwined. Our waters and water-related economy depend on the historic protections of the Clean Water Act and its pollution prevention programs. It is more effective and less costly to prevent pollution than to clean up pollution. This is true in Washington State. It's true across the country. When Congress passed the Clean Water Act over 50 years ago, members recognized the effectiveness and importance of comprehensive pollution prevention measures, stopping pollution before it happens rather than simply cleaning it up. The Clean Water Act was enacted on an overwhelming and bipartisan basis. Before this law, rivers and lakes served as little more than open sewers. Lake Erie was pronounced dead, and Ohio's Cuyahoga River literally caught on fire. Thanks to the Clean Water Act, the Cascade River in my district was recently designated as an outstanding resource water by the state of Washington, which now protects the river from any future activities or development that would degrade its water quality. In passing the Clean Water Act, the Congress specifically noted that a state-by-state, do-it-alone approach was, quote, inadequate in every vital aspect, end quote, and left waters severely polluted and expensive to restore. For decades then, Republicans and Democrats shared these bipartisan principles to defend clean water, maintain a strong federal-state partnership to protect waters, stop pollution from entering the system in the first place, and support a robust federal floor of protections while allowing states to do more but not less. After the Sackett decision, the robust federal protections for our nation's waters have been eliminated for more than 50% of wetlands and up to 70% of streams. History has shown that a lack of strong federal water quality protections makes it difficult and expensive for states to protect their waters if neighboring states adopt a lesser standard. States are now faced with a decision on how to handle pollution of the countless non-navigable streams, lakes, and wetlands once protected by the Clean Water Act. Some states will meet this challenge by establishing new state-level water quality standards for unprotected wetlands and streams, as the state of Colorado has done. Other states will choose to do nothing, or worse, pull back on state-level protections, like the state of North Carolina, leaving critical waters completely unprotected. Without uniform national protections, downstream states will be negatively impacted by pollution from upstream sources if neighboring states choose not to pass new protections. Last Congress, though, we did pass the bipartisan infrastructure law affirming our commitment to improving water quality infrastructure. The BIL included significant investments in water infrastructure, providing $13.8 billion in federal dollars for upgrading wastewater systems, preventing pollution discharges, and supporting restoration programs in places like the Puget Sound. These investments are critical, providing a lifeline to communities across the country struggling to maintain water quality. Such a large federal investment was a down payment to address the backlog of water infrastructure needs across the country. The Sackett decision reduces the federal role and the effectiveness of these investments. And the federal role reduces the federal role in the successful partnership that has been the Clean Water Act. If we're to maintain the same historic protections, states will have to step up and spend more resources on protecting water quality. Unfortunately, states will be doing so from scratch without decades of experience from the EPA and the Army Corps of Engineers. In this post-Sackett world, we must find ways to leverage federal experience in assisting states that are stepping up to maintain water quality protections. But Congress can do its job as well and legislate a solution. Passing the Clean Water Act of 2023, a bill I introduced in partnership with Ranking Member Napolitano, would restore the historic bipartisan protections that the Sackett decision removed. So I want to thank the witnesses for joining us today, and I look forward to your testimony. That'll yield back.
Gentleman yields back. I ask unanimous consent to enter into the record a series of letters regarding WOTUS implementation from the Associated Builders and Contractors dated September 11, 2024, Idaho Mining Association dated September 9, 2024, Associated General Contractors of America dated September 9, 2024, National Parks Conservation Association, September 10, 2024, National Stone, Sand, and Gravel Association, dated September 11th, 2024, National Mining Association, dated September 11th, 2024, State of Alaska Department of Transportation and Public Facilities, dated September 6, 2024, and finally, from 24 state attorneys general, led by West Virginia, dated September 6, 2024. Without objection, so ordered. I'd now like to welcome our witnesses and thank them for being here today. First, we have Emma Pocan, or is it Pocan? Pocan.
Either is just fine.
Well, which do you prefer, ma'am?
I think I say it Pocan.
Pocan. Commissioner of the Alaska Department of Environmental Conservation, Nicole Rowan, Director of the Water Quality Control Division at the Colorado Department of Public Health and Environment, Ms. Courtney Briggs, Chairman of the Waters Advocacy Coalition on behalf of the American Farm Bureau Federation, and Vince Messerly, President of the Stream and Wetlands Foundation on behalf of the National Association of Home Builders. So briefly, I'd like to take a moment to explain our lighting system to our witnesses. Fairly self-explanatory. Green means go. Yellow means you got about 45 seconds to a minute left. And red means, of course, conclude your remarks as quickly as you can. So with that, I also ask unanimous consent that the witnesses' full statements be included in the record. Without objection, so ordered. I ask unanimous consent that the record of today's hearing remain open until such time as our witnesses have provided answers to any questions that may be submitted to them in writing. Without objection, so ordered. I also ask unanimous consent that the record remain open for 15 days for any additional comments and information submitted by members or witnesses to be included in the record of today's hearing. Without objection, so ordered. As your written testimony has been made part of the record, the subcommittee asks you to limit your oral remarks to 5 minutes. And with that, Commissioner Pocan, you are recognized for 5 minutes.
Thank you, Chairman Rouser, Ranking Member Napolitano, and Ranking Member Larson, and members of the subcommittee. I appreciate the opportunity to testify today. My name is Emma Pocan. I serve as the Commissioner of the Alaska Department of Environmental Conservation. To start today, I want to emphasize the importance of this topic to the state of Alaska. Our state has 900,000 miles of navigable rivers and streams, 22,000 square miles of lakes, 27,000 miles of coastline, and more wetlands than every other state in the union combined, at about 130 million acres. It's estimated around 63% of the wetlands in the nation. And all of that is before you get to glaciers and groundwater. If you want to build a home, a road, a mine, or really anything in the state, you will likely impact a water of some sort. And where there's an impact to a water body, Alaska DEC is going to be working to ensure that impact doesn't compromise the water quality standards we've set to protect human health and the environment. Under the Federal Clean Water Act, Alaska DEC implements the Section 402 discharge permitting program, evaluates Section 404 dredge and fill permits for Section 401 certification, and assesses water quality throughout the state to ensure water bodies that fail to meet state water quality standards have plans developed to address that impairment. Importantly, I also have broad authority under state statute to establish and protect water purity standards. If you want to discharge to water in the state of Alaska, you need authorization from my team, regardless of whether it's going into a traditional navigable water body, a tributary, an adjacent wetland, an isolated surface water, or groundwater. In fact, in all 50 states, state agencies work diligently to do their part to protect waters in their jurisdiction. Many of these states, Alaska among them, apply the same water quality standards to all waters within their boundaries. You can see then, a lack of federal regulation does not necessarily mean no regulation, no government oversight at all. If EPA doesn't control an activity affecting water, state law and policymakers can make the judgment call about what level of protection is appropriate for their residents. And frankly, we're better suited to make those judgment calls. We have better visibility on the totality of circumstances for our residents. We're also more accessible to our residents, so there are better opportunities for the feedback loops that make democracy work. But the federal agencies do seem reluctant to trust states. Nationally, more than a year after Sackett was decided and the agencies published a revised rule, EPA and the Corps have still failed to address the indistinguishable concept and the vagueness concerns articulated by the court. Instead, we've seen worrying Chicken Little rhetoric from the administration. They have characterized the decision as a terrible threat to water. The White House itself has gone as far as declaring that the court decided the case incorrectly, essentially challenging fundamental constitutional checks and balances. Rather than developing a standard that can be understood and implemented by the regulated community and state partners, the agencies appear intent on leveraging uncertainty and threats of heavy civil and criminal liability to effectively maintain sweeping control across the country. If major elements of the Supreme Court guidance go unaddressed, we can anticipate continuing conflict and pendulum swings in implementation. That's not good for anyone. Without stability, states don't have certainty around what resources to consider committing to new or existing programs that regulate state-only waters. And the public we serve will continue to either go through unnecessary and expensive permitting exercises, getting approvals from the incorrect authority, or, as the court feared, choosing to forego productive activities on their land entirely. In closing, I would first remind everyone that states exist, we're here, and we're ready to do our jobs to protect state waters at the level deemed appropriate by our elected legislatures and chief executives. And second, I would posit that the field of water quality regulation would be best served by accepting the totality of the guidance provided by the United States Supreme Court and working with states to achieve our common objectives of a predictable, respectful, and rule of law-driven regulatory framework. Thank you.
Ms. Rowan, you're recognized for 5 minutes.
Thank you, Chairman Rouser, Ranking Member Napolitano, and Ranking Member Larson, and distinguished subcommittee members for the opportunity to testify before you today. My name is Nicole Rowan, and I serve as the Director of the Colorado Department of Public Health and Environment's Water Quality Control Division. Since 1975, our division has implemented the Point Source Discharge Permitting Program under Section 402 of the Clean Water Act. I'm here to discuss the implications of the Sackett versus EPA decision for the state of Colorado. The Sackett decision significantly impacted the arid and semi-arid states in the West. In Colorado, for example, approximately half of our streams are not relatively permanent, and around half of our wetlands do not meet the Supreme Court's continuous surface connection test. However, these wetlands and seasonal streams are vital to our environment and economy. They play a crucial role in flood and wildfire mitigation, water filtration, and habitat for wildlife. Natural systems act as a first defense against pollution, filtering out contaminants before reaching larger water bodies. They also support key sectors of our economy: agriculture, recreation, and tourism. As a headwaters state, our actions to protect water quality have far-reaching implications for our downstream neighbors. The Sackett decision had immediate implication for Colorado businesses. Some home builders and contractors that no longer needed permits from the Corps put their permits on hold because the state, lacking a dredge and fill permitting program, could not authorize these activities. However, placing fill material in Colorado waters was not allowed under state statute without a permit. Colorado sought to remedy this challenge by issuing an enforcement discretion policy shortly after the Sackett decision. This informed the regulated community that the state would not penalize those without a permit who notified us of their projects and implemented best management practices from the Corps' nationwide permits. Some larger projects, however, did not qualify for discretion under the policy. Colorado had to act quickly to allow these projects to proceed. Shortly after the Supreme Court heard oral argument for Sackett, Colorado Governor Jared Polis convened a task force to examine options for a state dredge and fill program. The task force had representatives from agriculture, water supply, construction, mining, oil and gas development, local government, and the conservation community. All agreed that Colorado needed a program to fill the gap left by Sackett. The task force proposed 4 different approaches, ranging from continuing to use enforcement discretion to full assumption of the 404 program. These 4 approaches were presented to a broader audience of stakeholders who were asked to provide written comments to inform state legislation. During the Colorado General Assembly's 2024 regular session, legislation was introduced authorizing our division to issue permits for dredge and fill activity for all ephemeral and intermittent streams and all wetlands in the state, which went further than just regulating the gap of waters created by Sackett. However, this approach provides certainty to the regulated community by eliminating a significant nexus determination. Through a series of over 45 stakeholder meetings with nearly 500 participants, we drafted clear exemptions and exclusions to this permitting regime that ultimately resulted in bipartisan support from the legislation for groups like Earth Justice and Sierra Club, as well as the Colorado Chamber of Commerce, Colorado Mining Association, and the state's largest water advocacy organization, representing over 400 water user interests, including water supply, agriculture, and local government. Governor Polis signed House Bill 1379 into law on May 30th, making Colorado the first state to enact legislation in response to Sackett. The bipartisan legislation ensures that federal 404 standards will continue while also addressing Colorado's unique needs. This approach provides much-needed regulatory certainty and also demonstrates that bipartisan solutions are achievable at the state level. Thank you for your attention and for allowing us to share Colorado's success story.
Thank you very much. Ms. Briggs.
Chairman Rouser, Ranking Member Napolitano, and members of the subcommittee, thank you for the opportunity to testify today. My name is Courtney Briggs, and I serve as chairman of the Waters Advocacy Coalition, also known as WAC, and as Senior Director of Government Affairs at the American Farm Bureau Federation. WAC is a multi-industry coalition representing a cross-section of the nation's construction, transportation, real estate, mining, manufacturing, forestry, agriculture, energy, wildlife conservation, recreation, and public health and safety sectors, all vital to a thriving national economy and providing much-needed jobs in local communities. It is an honor to be here on behalf of our trade associations and the thousands of members and millions of jobs we collectively support. Our members are committed to protecting our natural resources while maintaining their businesses. They live in the communities where they work and understand their responsibility in keeping our waterways healthy. However, the Biden administration's interpretation and implementation of WOTUS lacks clarity and certainty for landowners and businesses and stretches the federal government's jurisdictional reach beyond the limits of what is legal. Over the last few years, we've seen the Biden administration offer a new WOTUS definition, the Supreme Court hand down a highly consequential decision in Sackett, and then the agencies respond with a conforming rule and numerous agency memos. Despite a clear ruling in Sackett, there have been no clear directions from the agencies about which water features are regulated by the federal government and which are left to the states. Instead, the agencies are making up the rules as they go. They have failed to clarify the meaning of relatively permanent and continuous surface connection, which are crucial terms for defining the scope of federal jurisdiction. It seems the agencies want to leave these terms undefined, allowing them to exploit the gray areas that persist in a post-Sackett world. By leaving these terms undefined, the agencies gain unchecked power to regulate land and natural resources, creating murky waters for regulated entities. In this ambiguous regulatory regime, American businesses and landowners are left guessing where the line of jurisdiction lies, despite the severe penalties for Clean Water Act compliance. Either $64,000 per day for every day of noncompliance or jail time. It is thus all too easy for our members to unknowingly break the law. To put it simply, WAC members are tired of playing the agency's never-ending guessing games. The agencies have also neglected to provide clear implementation guidance to stakeholders. Instead, WAC members began hearing feedback that secret implementation guidance was being distributed by Corps headquarters to the districts, with strict instructions not to share publicly. The agency's refusal to release the secret guidance forced many WAC members to submit FOIA requests. The agencies responded with substantially redacted text, stating that the guidance was deliberative. How can something that is being used on the ground to make determinations that directly impact regulated parties be deliberative? The agency's implementation improv is putting our members' projects and the communities that rely on them at risk. This is a flagrant abuse of power and a blatant disregard for government transparency. Rather than offering clear guidance, the agencies are relying on memos haphazardly placed on their website with little public notice. Each memo gives a small snippet as to how they are implementing this rule, leaving stakeholders to play connect the dots with their livelihoods on the line. Many of the concepts outlined in these memos run counter to the decision in Sackett. The agencies offer no mechanism for appealing the memos, no opportunity for public comment. These memos are effectively rulemakings hiding in plain sight. It is unacceptable that 1.5 years since Sackett, the agencies continue to flout the court's ruling and hold project proponents and states hostage in regulatory limbo. Our nation's job creators, small businesses, farmers, landowners, and even states remain in the dark about how the rule is being implemented. This is especially concerning given the serious penalties for even negligent Clean Water Act violations, such as simply moving dirt in the wrong place. The agencies seem more interested in charting their own course than adhering to the Supreme Court's decision. Thank you so much for the opportunity to testify today, and I look forward to your questions.
Mr. Messerly.
Sorry. Good morning, Chairman Rouser, Ranking Member Napolitano, and members of the subcommittee. I appreciate the opportunity to appear before you today on behalf of the National Association of Home Builders. My name is Vince Messerly. I'm president of the Stream and Wetlands Foundation based in Lancaster, Ohio, and we're a mitigation bank sponsor and in lieu fee program sponsor. During the past year, the implementation of the revised WILDES rule, Post-Sackett, has been a tremendous letdown for home builders and wetland consultants. Particularly, this has been frustrating on two fronts. The agencies are not faithfully adhering to the Supreme Court's holdings, and the regulated public has been stiff-armed in the implementation guidance. We must be clear, the Sackett was not a controversial decision. All 9 justices agreed that the agencies exceeded their federal authority. The significant nexus test clearly overstepped the Clean Water Act. For decades, NEHB has advocated for a clear and predictable WOTUS. Housing production is linked to successful permitting. As a mitigation banker, I work in partnership with home builders to navigate the Clean Water Act. Our purpose is twofold: safeguarding the environment while allowing the creation of housing. Housing attainability is at an all-time record low. According to NHB's Priced Out study, nearly 80% of households are unable to afford the median price of a new home. The picture becomes more stark when you consider that for every $1,000 increase in a new home's price, an additional 106,000 homes or households are priced out of the market. Uncertainty and delays in permitting, especially as it relates to WOTUS, needlessly increase housing costs and turns the American dream into just that, only a dream. Here's how the EPA and the Army Corps missed the mark on the revised WOTUS rule. Instead of relying on the significant nexus test, the agencies are now relying on undefined regulatory terms, relatively permanent waters, and continuous surface connections. They left these terms undefined in the preamble before and after the Sackett decision. These undefined terms are being used to connect isolated wetlands to WOTUS via regulated streams or features such as ditches, swales, pipes, etc. This has morphed into a game of 20 questions for home builders and other project applicants asking how far away is just too far to document connectivity. The uncertainty and confusion are having significant impacts on the home building and infrastructure projects. Based on the agency's 10 coordination memos, we can gather 195 feet is a relatively short distance and can be used to determine jurisdiction, while another example, 2 miles away, is just too far. The court was clear. To assert jurisdiction, a wetland must be adjacent to WOTUS. And to be adjacent, wetlands must be indistinguishable from the waters of the United States, meaning there must be no clear demarcation. Yet the agencies are tracing connectivity between features that are clearly distinguishable. Last December, Congressman Duarte shared before the subcommittee during a hearing with Michael Connor of the Army Corps of Engineers his personal experience with swales being wrongly used to establish connectivity. As for transparency, during the same hearing, Mr. Connor said that the agency's implementation guidance will be a public process. Unfortunately, that has not manifested. The agency's issued final Post-Sackett rule invoking the APA, good cause exemption, which precluded public comments because it was deemed unnecessary. Given that our members are unclear on the WOTUS regs, NEHB has sent a FOIA request to the Army Corps requesting implementation guidance. Over 6 months later, NEHB finally received a formal response with reams of redacted information. And some of the only unredacted information we received were multiple copies of the same slide deck used for public seminars. Regrettably, these webinars were one-sided. We were invited to participate, but our lingering questions surrounding WOTUS implementation were completely sidestepped. Moreover, during a March 22nd stakeholder meeting with NEHB and others, EPA was asked whether their coordination memos were nationally binding. This is a critical issue because under APA, national binding documents must be open for public comment. As we tried to proceed for an answer, the EPA simply ended the conversation. To boost housing production and improve affordability, the residential construction industry needs a clear and predictable Section 404 permitting process. This predictability can be achieved if Congress codifies the definition of relatively permanent waters and continuous surface connections, or alternatively, tells the regulated community what features do not fall under these definitions. Thank you again for the opportunity. We look forward to working with you, and I'm glad to answer questions.
Thank you very much, and thank all of you for your great testimony. Ms. Pocan, I appreciated hearing your testimony about the important role that states play in regulating and implementing water quality standards. And as mentioned in my own opening statement, this is the key part of the Clean Water Act that many people choose to ignore. What has the state of Alaska's experience been post-Sackett, and what are you hearing from the Army Corps of Engineers in Alaska?
Thank you, Chairman. We certainly have been watching the 401 certifications come through to kind of get a sense for if there's been a change in the Army Corps of Engineers implementation of the 404 program. And not seeing any clear indicators, we have met with our district office. The message that was delivered to us was essentially that in Alaska, nothing has changed. Nothing. They did tell us, well, we pressed for some more specifics, like are there some general principles that are being applied? Is there something that you can share with us about what the standard is? And it sounded like, well, they repeated that they're determining it on a case-by-case basis. They did share that for the North Slope of Alaska, which is an area about the size of Utah, that they consider much of that area to be jurisdictional because of permafrost wetlands. Now, those wetlands aren't forming because of a relationship with a jurisdictional water. Those wetlands are forming because the upper layer of permafrost is melting. And so you have this massive area that just by virtue of being a wetland that is adjacent to a wetland that is adjacent to a wetland is adjacent to a wetland that is then abutting a navigable water body. There doesn't seem to be any limit to this contagion, that as long as on the surface there is an ecosystem that can be characterized as a wetland, there are saturated soils, the Corps of Engineers will claim jurisdiction over that. They also made some comments that called into question whether or not they're even looking for surface water, or whether or not they're looking for any flow of water to indicate connectivity of the water between the wetland and a jurisdictional water.
Thank you very much. I wish we had more time. Ms. Briggs, you talked about the challenges that your membership is facing. Of course, agriculture is taking it on the chin on any number of fronts that you look at. Can you talk a little more specific to that and how this is such a challenge for America, our American farmers who are feeding and trying to clothe not only us but the rest of the world?
Yes, thank you, Mr. Chairman, for the question. And I'll remind everyone that food security is national security. So our farmers and ranchers have the most important job in the world. WOTUS continues to be an issue. The problems that I already outlined, the lack of clarity with the rulemaking, and now no implementation guidance. They're not giving our members the roadmap on how they're expected to follow the law. That's really all my members want to know. What is in and what is out. But a lot of people like to say, well, farmers have all of these exemptions, isn't that nice? And they don't have to comply with the Clean Water Act. That is absolutely not true, because the exemptions that have been provided are not clear. An exemption is only as good as how clear it is. So I don't understand why the agencies are hiding the ball on implementation. I don't understand why they will not come back and clarify these terms post-Sackett. And our farmers are really hurting out there because of it.
Mr. Meserly, you touched on regulations and the cost to, the cost to building a home, which obviously translates to cost to a home buyer. How much extra cost are people paying for when they purchase a home just simply due to regulation, beyond just WOTUS, but WOTUS included?
Well, thank you, Chairman Rouser. Good question. Cost, and as a mitigation sponsor, we can speak towards that. And so just as a for example, in Ohio, the typical applicant mitigates at a ratio of 2 times of what they impacted. A simple nationwide permit, which is impacts of less than a half acre, would require 1 acre of mitigation. An acre of mitigation in Ohio would be about $70,000 on average, sometimes a little more, sometimes a little less. So when you apply that to the cost of a small business project or a residential construction project, that cost can be overwhelming. That cost for the mitigation does not include those costs that are affiliated with retaining an attorney, an engineer, a surveyor, a wetlands biologist, not to mention the time of processing the permit. The substantial amount of time passes. These are things that the permit applicants has to bear the cost of up front, and that can really be stifling. And by that I mean is that's not something they have a loan for. This is something they're paying out of pocket until they secure that permit and the project can be implemented. There are a lot of permit applicants that never get submitted. They die before they ever get there just because of the overwhelming cost.
Yeah. Those that scream about affordable housing, and we all want the most affordable housing possible, are the same ones who put all the regulations in place that keep it from being affordable. Anyhow, just an editorial comment. I yield to my good friend, Ms. Napolitano.
Thank you, Mr. Chair. Ms. Rowan, you testify the impacts of Sackett decision are particularly stark in many western states, such as Colorado, where water both increasingly scarce and vital to the long-term economic, environmental, and social health of our communities. I believe that every state-go-it-alone approach is inconsistent with congressional intent on the Clean Water Act and will likely result in increased costs and decreased water quality available for our communities. What are your perspectives? Do you agree?
Thank you, Ranking Member Napolitano. Yes, we agree. Colorado's a headwater state, and our water flows to 17 downstream states, and protecting water quality is very important. I think an example of that, a recent example is our work with the state of Kansas. We've been working to address salinity issues across the Arkansas River and Arkansas River, as they call it in Kansas, on both sides of the state line, particularly focused on protecting agriculture.
And my state is currently dependent on other upstream states for much of its municipal, agriculture, and industrial water supply. I applaud your state's efforts, but recognize that not all states prioritize or invest in protecting interstate water sources of water. What is the likely consequence if bordering states place different priorities on protecting what are, in essence, shared multi-state water resources?
Thank you, Ranking Member Napolitano. I think one thing that we've appreciated about federal standards and other parts of the Clean Water Act that we implement is that there is a consistent and uniform federal standard, and it provides some level of protection. I think what we hear from businesses is having a uniform standard is good for business, and it provides the certainty that the regulated community needs.
Thank you. What is the economic impact to American families, businesses, and farmers if existing sources of potable water fail to protect or, worse, eliminate due to neglect, destruction, or pollution?
Thank you. I think one of the things that we've been really focused on in Colorado is making sure that those impacts don't occur. And that's why we were so quick to stand up enforcement policy and work to pass this legislation in Colorado.
Thank you. I believe the question of who should ultimately be responsible for protecting rivers, streams, wetlands has become hyper-politicized, and some parties now are unwilling to engage in meaningful conversations on involving this decades-old issue. You've done a wonderful job on that. Yet you discuss the success of your state in negotiating with often competing sectors within your state, including the agriculture, water supply, construction industry, and conservation communities. Any advice for us in Congress to promote a meaningful dialogue on this issue?
Thank you, Ranking Member Napolitano. I think we worked incredibly hard to gain common ground across a variety of different interest groups, and one of the key stakeholders to our process was Colorado's agricultural community. One of the things that we did in the legislation was to adopt the 2020 Navigable Waters Protection Rule related to prior converted cropland, which was a big desire by our agricultural community. We also worked very hard to define exclusions and exemption for irrigation ditches, which are the lifeblood of agriculture in Colorado.
Thank you. Mr. Chair, I'd like to introduce to the record
Without objection.
American Rivers, letters from American Rivers, Audubon Society, Clean Water for All, National Wildlife Federation, Southern Environmental Law Center, and Protect Colorado Water Coalition.
Without objection, so ordered.
Thank you. Yield back.
Gentlelady yields back. Now recognize Mr. Bost.
Thank you, Mr. Chairman. So now here we are, a year into the Biden administration's new WOTUS ruling, and nothing's changed. There's been no regulatory clarity, no real guidance, no communication with the public. While the administration may be okay with this, there are serious implications for our landowners and industry stakeholders. Ms. Briggs, you noted in your written testimony that landowners can be fined up to $64,000 per day or receive jail time for any clean water violation. I'll repeat that again, $64,000 or jail time. That's not small change for a simple mistake or a misunderstanding. That's devastating to any landowner or small business. Now, Ms. Briggs, from a farming perspective, can you speak to the challenges that the farmers have faced under this administration's poorly amended WOTUS rule, and how easily it may be for a landowner to make a simple mistake and be in violation and look at $64,000 a day in jail time?
Yeah, after the Biden administration's rulemaking came out, then after Sackett, then after the conforming rule, we heard it was at a fever pitch, the amount of confusion and concern and uncertainty that we were hearing from our members. And it is incredibly easy for our members right now under this regulatory regime to unknowingly unknowingly break the law and be subject to all of those penalties that can frankly put a member out of business. I mean, we represent so many small businesses who don't have the ability to absorb those kind of costs, and it's $64,000 per day for every non-compliance on the farm field. So that can add up quickly, and it can be absolutely devastating. But with this level of uncertainty, it is unfair to our landowners. And again, I just don't understand why the agencies won't come out, clearly tell landowners what the rules of the road are. It's like, I like to take my kids to the pool every now and then, and it's like that pool sign where it says all of the rules, and it's, no jumping, no splashing, no glass. And then at the bottom it says, if you violate these rules, then you will lose your membership to the pool. Well, imagine that is the sign for our landowners, but all of the rules have been blacked out, and at the bottom it says you could be subject to $64,000 a day or jail time. It just doesn't square.
Well, welcome to our world, because it's every administrative body under this administration. At any rate, Mr. Meserly, based on your testimony and what I'm hearing from my constituents, I think we can both agree that the permitting process here is a mess. It's costly, it's slow, it's killing infrastructure projects. Thousands of small projects die before the builders even have the chance to apply for their permit. And a simple nationwide permit to impact just 1/2 acre of wetland can easily cost upwards of hundreds of thousands of dollars. You've shared that at your nonprofit, we work with over 1,500 permit applicants developing infrastructure projects. Can you share with us real-world examples where WOTUS permitting has significantly delayed or even caused a permitting applicant to just walk away?
Good question, and I'd be glad to share. I don't have clearance from particular permit applicants to share any names or anything, but it happens quite often. Usually it's small business owners that call, and they just never even bother to apply after they talk with me and find out what the cost is. But there are times where it's even large companies that want to develop projects. One project stands out in my mind. Northeast Ohio, the applicant wanted to impact wetlands to build a large commercial operation. Their siting criteria needed it to be near an interstate highway, needed to be within a certain distance of the public. They wanted to site it in an urban area for traffic, for business. In that particular project, it was determined that this, I will say, moderate quality wetland that was surrounded by a railroad, industrial park, and an urban arterial highway was too good. It was determined to be regionally important and therefore could not be impacted. The applicant withdrew the permit, built the project about 100 miles away, different city, different community. The community lost out on the job creation.
I think what we're seeing here today, and I know my time is up, Mr. Chairman, but what we're seeing here today is what we've known for a long time about our WOTUS rule. It is ridiculous not being able to know where the government lies and what in the world they can do to you and when they can do it. And that's a shame because it stifles growth and scares many of our landowners. Thank you. With that, I yield back.
Mr. Larson.
Thank you, Mr. Chair. First off, appreciate the concerns members have about a lot of things that Congress does and the Supreme Court does, the administration does, but we don't need to be overstating impacts. In fact, in nearly 3 years, the bipartisan infrastructure law has provided $480 billion to 60,000 projects that benefit every congressional district in the country. The AGC was here a few weeks back to testify that nearly every county in the country has a project being built because of the bipartisan infrastructure law. The numbers I just cited are corroborated by ARTBA, the road builders. So to make broad statements that projects are getting killed every day because of WOTUS does not actually line up with the facts. I know fact checking around here gets people a little dicey, but those are facts. I'm sure folks will have some things they want to say about what I said here, and that's okay. But let's not overstate the challenges or overstate the problem itself. Because there's another set of the problems that the Sackett decision brings, and that's undermining just the basic principle of cooperative federalism that Ms. Rowan had discussed in her testimony. Before the Clean Water Act and adoption in 1972, an individual state's efforts to protect the health of its waters could be undermined by the actions of its neighboring states. And so, Ms. Rowan, what challenges Colorado face in protecting its water resources from interstate pollution?
Thank you, Ranking Member Larson. We are a headwaters state, and so, water from Colorado flows to downstream states, 17 of them, and protecting our water quality within Colorado, but also in the water that is delivered downstream is of critical importance, and it's something we take very seriously.
Have any of these states written a thank you letter to Colorado for protecting the cleanliness of their waters yet?
Thank you, Ranking Member Larson. No, we haven't received any letters to that.
Would you substitute a thank you letter for them taking action in their own state to increase their water quality programs?
Thank you, Ranking Member Larson.
You don't need to thank me for anything.
I think, we closely collaborate with a number of our states through implementing the 402 program and have for years, and have regular dialogue. We do have an active partnership right now with the state of Kansas, really focused on.
Yeah, you mentioned that.
Yeah.
Well, I wouldn't want to replace a thank you letter with the states actually taking actions, or as opposed to doing nothing because Sackett passed and using Sackett as an excuse to not protect their waters. It just seems to me returning to a pre-Sackett system of uniform federal protections would be better than a patchwork approach is what we have. But if we're stuck with it for now, how can the federal government better assist states to protect their wetlands and downstream water resources? Ms. Rowan.
Thank you, Ranking Member Larson. I think we do appreciate some federal standards. It does provide some level of protection for states to shoot for, and that uniformity is appreciated. And again, we think that this provides regulatory certainty to our industries and development and economy in Colorado.
Yeah, my first hearing on, and I mention this all the time to the committee, my first hearing on the waters of the U.S. was back in, I think, 1824. No, it wasn't that long ago. It was in the mid-2000s, I think, and anyone who thinks that this hearing is going to resolve this issue today, or even that the Sackett decision is the last word on this, I just don't think history backs that up, frankly, right now. Either congressional history, administration history, or, Supreme Court history. Had the Supreme Court then decided, give us one decision instead of two decisions, with Rapinos and with Swank, then we probably wouldn't be here, but they did. And I just think we'll be at it again. And I look forward to the next 19 hearings we have on WOTUS to resolve this. Thank you very much. I yield back.
Fun. Mr. LaMalfa.
Thank you, Mr. Chairman. I appreciate the opportunity to have this hearing, whether it takes us one or 19 more, because indeed, Clean Water Act and many other environmental measures have been weaponized to stop people from doing much things. Look at the Sackett decision itself. They wanted to build a stock pond on their own land and were thwarted for many years and much pain. And if you want to look at a Clean Water Act problem, I invite the panelists and everybody else to take a look at the Klamath River post-dam removal and how nasty and mucky and silty that river is, with little regard towards what would really happen. They were just so hot to get those dams out. Anyway, so I guess this would be tilted towards Ms. Briggs and Mr. Messerly as well. In my home state of California, where it's near impossible to build housing in areas where it makes sense, open areas like that, except for in floodplains and where agricultural land is, because there doesn't seem to be any critters about there that they care about. So, Mr. Messerly, for example, in Butte County, we have something called meadow foam, and they seem to think there's several different species of meadow foam. So, If it grows in what's called a vernal pool, which holds water for a few minutes after rain, that is a wetland and that's an endangered species. Meanwhile, they're growing meadow foam up in Oregon as a seed oil plant. And so you have this, but prime areas where housing could be built outside of floodplains and outside of agricultural land is unusable. So speak about what you might know about California's situation on trying to build housing, especially since houses in California are starting to average 500, 600,000 in most cases to build anything, if you can build it, such as around Chico, California, which they got shut down once again.
Not sure I quite followed all your question.
Well, I threw a lot out there.
But
So
you're-
just talk about availability of building homes and what it's doing to the price structure, especially in California for normal people.
Yeah, and, you know, in an agricultural area, you know, and Courtney could address this as well, but, you know, the question would be, are these waters of the United States, is it prior converted cropland or not? And, you know, from a species standpoint, I'm not familiar with the species in California, but this one that you're talking about sounds like it could be very difficult to identify, but it's also rare, and that makes it even more harder to identify.
Well, it's not rare in Oregon if you're harvesting the stuff, but it's called meadow foam, and it's fairly prolific, but it seems to be protected, and it prevents homes from being built or other stuff on suitable land.
And so, you know, that ties in a whole nother topic, the Endangered Species Act, and that intertwines, you know, because of the nexus of the 401 and 404 permitting programs, you get pulled in by the ESA as well.
Well, they use the Clean Water Act in order to have the waters of the United States apply to every vernal pool, which was some of these grow in. Ms. Briggs, you've heard the situation here where land that had been idle but had been farmed extensively in the past, but for some years was idle, and then you go back to start farming it again, and you're in trouble from the EPA along with Army Corps for somehow violating the Clean Water Act, which I would tell you, when this was passed back in the 70s by Congress, if Congress would have passed a bill that's being interpreted the way it is now to stop any type of development or farming, Congress, those members of Congress who got thrown out on their ear for passing such a bill. It's been reinterpreted time and time again. So Ms. Briggs, talk about how unfair that is that you've had farmable land and that they keep changing the interpretation of the WOTUS rule. From 2008, it was changed by Obama up until 2015, then it was only applied to half the country, and then President Trump was able to change it in 2020, which was promptly rescinded by Biden in 21, which led us to the Sackett case in 23. How much sense does this make, trying to farm under all these conditions? You talked about the pool rules.
Oh, I mean, it's incredibly difficult with the pendulum swinging back and forth and the ping-ponging of rules based on changes of administration. There's no clarity, there's no certainty for our members. So they just don't understand where that bright line of jurisdiction is. It doesn't exist under these rulemakings. And you talk about, you know, land that's been idled in California. Again, the ag exemptions are only as good as how well they're written. And we have problems with prior converted cropland. We have problems with the exemptions that are listed in 404F, because when you talk about normal farming practices and that being exempt under 404, right behind it is a recapture provision that essentially says you're exempt unless we tell you you're not. So no farmer has certainty in using any of those exemptions, and unfortunately we've seen farmers burned by both compliance under Swamp Buster and the Clean Water Act.
So the list of rules always has
An asterisk.
at the end of the rules and any other thing we feel like enforcing you on, which is the one they gig you on.
There is always an asterisk associated with ag exemptions. We can take this away from you at any time if we feel like it. You know, I'm paraphrasing there. But.
No, you're right. Well, they're sure good at gigging us, but I see them not very on time producing reports and things we asked for here, or they're heavily redacted like was talked about. So, Mr. Chairman, we got a lot more to do on this. Thank you, and I yield back.
Ms. Norton.
Thank you, Mr. Chairman. First, let me say I strongly opposed the Supreme Court's decision in Sackett versus Environmental Protection Agency. I urge this committee to take up legislation to overturn the Sackett decision and restore Clean Water Act protections for the nation's rivers, streams, and wetlands. Ms. Rowan, what is your view of the pace of the implementation of the Conforming Waters of the United States rule?
Thank you, Congresswoman. You know, our law in Colorado is really filling the gap left by the Sackett decision that was then taken into account in the conforming rule. So that is really what we're focused on, is filling that gap. We've worked really closely with the Corps of Engineers, you know, both after the Sackett decision and as the rule has been implemented, to understand what they're taking jurisdiction over and then what would be in our purview to work on permitting in the future. And that's been a very collaborative relationship, and they've provided a lot of good information for us as we've been navigating the process.
Ms. Rowan, do you support legislation that would overturn the Sackett decision and restore protections under the Clean Water Act? And if so, why?
Thank you, Congresswoman. I think returning to a pre-Sackett regime, would provide, a uniform level of protection across the United States. We have found that businesses and regulated entities really like certainty, and especially when they're working across different state lines and the different businesses, it does provide them the certainty from a regulatory perspective.
Thank you. And again, I urge this committee to overturn the Sackett decision, and I yield back.
Mr. Burleson, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Mrs. Briggs, last year the Supreme Court obviously struck down the decision, but it seems that the EPA is completely ignoring it from your testimony and everyone's testimony here. And there are some examples of this. The EPA prevented Dan Ward, a farmer in Iowa, from building a pond on his land. Robert White from North Carolina filed a suit against the EPA because they are ignoring the rule of law from the Supreme Court and still regulating his land. So even though Sackett decision should be preventing the EPA from imposing these, they're still acting as if the decision doesn't exist. So the question is, what can we do? What can we do to ensure that the EPA is following the decision of the courts?
Well, you can pass a law codifying the Sackett decision. I think that would be helpful if it was in the statute. But I just want to take a minute because you mentioned specific instances of people being harmed. I don't think that I am exaggerating the impact that this is having on WAC members. I hear about people who have to walk away from projects, walk away from revenue for their small business, walk away from creating jobs in rural communities because of this regulation. And frankly, this is one of those regulatory rulemakings that makes the next generation of farmers not want to get in farming. So there is a real ripple effect here that I think folks are failing to acknowledge.
One of the issues that we faced in Missouri was that you have your state department that's enforcing a lot of the regulations because the EPA doesn't have the manpower or the resources to do so. So with a little bit of money, they influence and require the state resources to enforce them. In our state, it's the Missouri Department of Natural Resources. I assume that's the way it is in every state to some extent. And the question that I have is that what we experienced is that the EPA may not have a rule. They may not pass anything formally, they may not go through the rulemaking process. Sometimes they'll just issue a guidance document. That guidance document, the state enforces as though it's a rule. And yet no one elected to anything made a change. I don't know if you could comment on that.
Yeah, so thank you, Congressman. So the field memos that I mentioned in my testimony, again, they give you little bits and pieces about how they intend to implement this rulemaking. And I think if you take it all collectively, it's really a rulemaking hiding in plain sight. Like it has the effect of a rulemaking.
Right.
And the fact that that has not gone through notice and comment, it hasn't gone through stakeholder engagement, is really a problem. So, the fact that they are taking these guidance documents and applying them as rulemaking is very concerning. But they will not hand over the implementation guidance that is being disseminated to the core districts. We know they exist.
Do you have to do a FOIA request for that, or?
This is the response we got. 1,123 pages, most of it is redacted. I will point you, and I'm happy to send this to you, to one page where they talk about, here is the implementation guidance that core districts should be using. Here's the SharePoint, and they black out the SharePoint. There is evidence in here where they say, do not share this with the public. Read the FOIA response. I'm happy to share it with the committee.
So there's no transparency at all. Ms. Pocan, I could see that you might have some thoughts on this, that how the states are being leveraged to be the enforcer for the EPA when there's no real actual laws or elected officials involved.
I'll say as a state agency that works with the EPA both in implementing the federal program but also in implementing our own, I haven't seen the guidance that was been provided to the Corps of Engineers. And so I don't know if when a permittee comes to our agency, if I need to issue them a state permit under state authority or if they should be getting a federal permit under the Section 402 program. And I think that while we implement the same water quality standards statewide, that can matter for a lot of different reasons. I might take a different enforcement approach with an entity if I have more flexibility and support them getting into compliance rather than having to act in a way where we fear that EPA is going to come crashing in over our shoulders and enforce over us. I also have more flexibility in adjusting specifics of the program in a timely way to support facilities that need to operate. When we have to send things to our regional office for approval, it can be quite a lengthy process to get something finalized.
Thank you. I yield back.
Ms. Skelton, you're recognized.
Thank you, sir. Thank you to all of our witnesses for being here today. This is an incredibly challenging time. I serve the great state of Michigan, including miles of beautiful West Michigan coastline, one of the largest freshwater estuaries in the entire country, the largest river system in the state of Michigan, all within my district. To say this is an essential conversation is truly an understatement. Ms. Briggs, while I agree with you that particularly in our ag community, we are experiencing incredible uncertainty, the Sackett decision has undermined our ability in significant and meaningful ways to protect this precious, non-renewable natural resource. Despite state-level efforts to bolster water regulations, there is no guarantee that our neighbors will pursue the same protections under the Sackett decision, as water can cross state lines. We see that in the Great Lakes region as clear as when you pull up a map. This ruling may ultimately hinder Michigan's efforts. We're one of 3 states which has been designated the authority to govern our own wetlands to enforce those laws. Ms. Rowan, Colorado has similarly sought to maintain strong water standards at the state level. Can you speak to the burden states that have led in safeguarding their waters must carry without strong and consistent federal protections post-Sackett.
Thank you, Congresswoman. So I think an immediate need for our state, again, was making sure that the uncertainty that was left behind didn't hinder economic development and progress. And so, we had to really get creative quick and develop an enforcement policy. And we were fortunate enough, to have our legislature move forward, based on a lot of stakeholder support and common ground for a solution in Colorado that can hopefully withstand some of the back and forth that we've seen at the federal level. I do think that, one burden that we are facing is that we had to, put state dollars together to fund this program and be able to issue timely permits in the ways that our regulated community deserves and desires. And so that's one big impact is the financial burden.
Thank you. As I mentioned, Michigan is home to the largest freshwater estuary system in this region, arguably in the world, considering the Great Lakes being the largest reservoir of fresh water. Also home to 275,000 acres of Great Lakes coastal wetlands, which are incredibly biologically diverse and imperative to the health of the larger Great Lakes basin. However, these coastal wetlands connect to groundwater sources and may be at risk as the groundwater connects below the surface, not meeting the post-Sackett definition of waters of the United States. Again, to Ms. Rowan, can you elaborate on how essential these wetlands are in ensuring water quality standards and healthy habits, as well as how Sackett may harm critical groundwater sources linked to these wetlands below the water surface?
Thank you, Congresswoman. Coming from an arid West state, our water is very important and valued, and, wetlands provide a very critical way to and a natural solution for filtering pollutants and protecting downstream water supplies. And, also have an impact on protecting our groundwater sources, which are used for a variety of ways in Colorado for agriculture, drinking water. And so it is just vital that we did find a way to protect this resource in Colorado.
Thank you. I invite anyone else to offer comments in the remaining few seconds that we have.
Could I add?
Yeah.
Thank you, Congresswoman. I empathize with the concern over state resources and having adequate funding, and applaud Colorado for making that investment. I would add, though, that I don't know that, so under our 402 program, for example, which is where the federal government has jurisdiction and we are implementing a federal program, funding is grievously short currently. And so for our program, for example, we get about, $1 million, $1.5 million through EPA and federal funding for that program, and then we invest $5 million of state funds. So I think a lot of states are already providing an investment in protecting their waters. And so I don't know that the post-Sackett world is necessarily that dramatic of a change, but I do think that if EPA and the executive wanted to better support states in protecting our waters, that funding the federal programs that we're implementing would be a good step in that direction.
Thank you. I appreciate that. And, again, without clean water, we're not going to be able to enjoy the incredible apples, blueberries, asparagus, and the vital ag industry that we have. And, again, believe me, I hear you on the uncertainty. Our farmers are existing in the margins right now. This is a serious issue that demands a serious response from legislators on both sides. Thank you again for your testimony today. I yield back.
Gentlelady yields back. Ms. Malloy, you're recognized.
Thank you, Mr. Chairman. I've been sitting here listening to this, and I've done a lot of work in permitting and project planning in my career, and it seems like a lot of the conversations about this start from the assumption that if the federal government isn't managing something, if they don't have jurisdiction over something, if we don't define it as WOTUS in this particular instance, that it's going to get destroyed. And I appreciate all of your testimony because I hear all of you saying that we're actually doing a pretty good job of managing in the states and even in industries, and that we don't have to start with the assumption that the federal government isn't doing it. It won't be done correctly. And I like that because government's a blunt instrument. And one of the other things I'm hearing is that people who are required to comply with this, which is everybody, don't know when they're in compliance. And because the full power of the federal government is behind this, that's a really scary situation for someone to be in. So I'm going to filibuster here for a second, and then I do have questions. So I heard from my constituents that the Corps of Engineers released a 143-page manual to its people in order to help them determine when someone's in compliance. If you are at the Corps of Engineers and you have to have a 143-page manual to determine compliance, it really seems like that's going to be a problem for a family that wants to build a stock watering pond on their land. They're just not going to be able to make that determination, but they could be facing potential jail time and the kind of fines that nobody can actually afford. And then I represent Utah, and in Utah we have a lot of ephemeral streams. We get snow melt, like you do in Colorado and Alaska, and it runs downhill, and if we have a good snow year, there might be water in places we don't normally have water, and if we have not a great snow year, there's not much water. And it makes it really tough for people to figure out how to apply these definitions to places in Utah. And I have a responsibility to represent my constituents who can't figure out with a 143-page manual and a bunch of letters from agencies whether they can move forward on something. So my first question, and it's for all of you, we're going to start with Ms. Pocan and go down the list. In your experience, do these long processes of getting permits create better outcomes?
I think I can confidently say that the process could be better streamlined, particularly where there's a federal intersect. As I mentioned earlier, if we want to adjust our approach based on site-specific circumstances or other conditions that are unique to a facility or to a location, that can be a quite lengthy process working with the federal government.
Yeah.
And so lengthy that often it just doesn't work for the facility that needs to be able to operate. So then they're faced with either not operating and maybe giving up the business plan, or operating in non-compliance, which also isn't a good option that they want to follow through with. So yeah, I think that the process could be improved. I also think that states tend to be a little bit more nimble, and we have the awareness of a fuller totality of circumstances that are affecting our facilities and our residents.
Thanks. So I'm going to put you down as a no. It's not actually creating better outcomes. It's just a lengthy process. Ms. Rowan?
Thank you, Congresswoman. I do believe that there are good outcomes from the permitting process. I think when it comes to our wetlands and seasonal streams, what we're talking about here is kind of losing chunks of them in their entirety, and it's hard to get them back. So I do think that the permitting process helps protect in that regard. I think also in Colorado, our history has been that the vast majority of the permitting proceeds under the general nationwide and regional general permits, which
I'm going to rush you a little because I'm almost out of time.
sorry.
I had a couple more questions I wanted to ask. Ms. Briggs, does the length of the permitting process help the outcome?
No.
Thank you. Mr. Messerly? Thank you. So it seems like
No,
the
ma'am.
court made a move to limit the jurisdiction of these agencies, said they're overreaching in Sackett, and then in light of the Chevron decision, it seems like the court is signaling that they don't want agencies to keep overreaching their authority. But we're sitting here talking about how agencies are trying to go around that and redefine it, and that they're defining their authority as if we have jurisdiction, then people are safe. I just don't think that's true. My last question, if you guys can answer it really fast, is how much do you think it's costing people you represent in time and money to get these permits? And we're going to start with you, Mr. Messerly, because we're going to run out of time really quickly.
A lot. A basic permit I mentioned earlier, $70,000 for mitigation, consulting fees, attorney fees, et cetera. On top of that, easily puts it over $100,000 just for a general permit. On average, we typically see applicants needing upwards of 2 acres of mitigation, so it just escalates from there, multiplier, and so it's very expensive.
Thank you. I want to hear your answer, Ms. Briggs. I'm out of time. I don't know how 5 minutes
I'll
went by
just say
so
the cost
fast.
of delay.
Yeah, I'm going to follow up with all of you in writing for answers on this and the other question I didn't get to, because I think this is really important that we get answers. Thank you.
Gentlelady yields back. Ms. Hull.
Thank you very much. My questions are for Ms. Rowan. Thank you for being here today. My questions are because, you know, Oregon, like Colorado, we have state protection laws and that now differ from the federal laws, and we're all trying to work out how we interpret these things. So as you've worked with the EPA and the Army Corps while developing your program, you know, what have you found most helpful in the technical assistance that's provided, and where do you feel like you could have better technical assistance?
Thank you, Congresswoman. Thank you for that question. You know, one of the things we did in crafting the legislation was really hearing from our stakeholders about what's working about the current federal process and trying to get an understanding of what not to take away, because they actually like certain portions. And the Corps was very, very helpful in, as were our stakeholders, in helping us understand how exemptions and exclusions how they operate in Colorado. And one of the things that we did with the legislation is, really have a more expansive set of exclusions and exemptions for the variety of activities and water body types in Colorado. So they were very helpful in helping us understand how that's worked historically. I think another area where we are going to continue to work really hard, and I think we have a unique opportunity as a state, is how we do mitigation moving forward. And so I think that's going to be critical as we stand up our new program.
Thank you. Also, do you feel like you've had the clarity provided that's necessary to determine state versus federal waters?
Thank you, Congresswoman. We are really focused on, again, filling the gap that Sackett left behind. And so the Corps has been working very closely with them to let us know when a water in Colorado is not a WOTUS, so that we can work with those entities to make sure that they have what they need to keep moving forward with their project under our enforcement discretion policy and now as part of our permitting program.
All right, and then could you just go into more, I know you've touched on this, what's been the feedback and public perception for affected parties and stakeholders of how WOTUS has changed in your state?
Thank you, Congresswoman. After the Sackett decision, the Nature Conservancy did a public survey in Colorado from voters from all political affiliations statewide. And what that survey found was that 67% of those surveys really wanted to see some state level of oversight to fill the gap.
Excellent. Thank you, and I yield back.
Mr. Collins.
Thank you, Mr. Chairman. I'm going to jump right in. I've been jumping around like a jumping bean, I think, here this morning. Mr. Messerly, Home Builders Association. I just want to start out, if you could, give me some real-world consequences of an ambiguous definition to WOTUS, and what does it exactly mean for my constituents?
So Mr. Collins, make sure I understand your question correctly. You're asking, what is the definition of water in the United States?
Well, it's ambiguous at best. So, what's it? What are the home builders out there seeing, and how is it affecting my constituents?
Yeah, the biggest effect, to be honest with you, when you look at the definition of water in the United States, the vast majority of the definition is very clear. Navigable waters, territorial seas, oceans. In the 1890s, they defined.
What's that got to do with home building?
But when you get it down to, by the time you get to the headwaters, where they're building houses, where they're farming, where they're ranching, where they're mining, those are where the rub is. And those waters need to have a continuous surface connection with the relatively permanent water.
So when your builders are getting permits and they don't know if the water is federally, if the feds have jurisdiction or the states, right? That's where we're going with this. So what do? They just, they bide their time and wait till the good old federal government, who we all know works at a pace of a snail, going backwards?
Well,
they just give up, throw their hands up and say, hey, let's just go ahead and pay everything we need to and get this out of the way.
sometimes they give up and sometimes they concede, other times they walk away.
Does that actually cost the home builder, the person buying the home at the end of the day?
At the end of the day, that cost gets passed on.
You got any estimates?
To that person living in that home.
You got any estimates or anything on what you think it's costing? Does it add 20%?
It could easily add that. If you're building for a single residence, it could easily add more than that. But you're talking, again, anybody, from an affordability standpoint, from a financing standpoint, every $1,000 of increase in a house takes away 106,000 eligible borrowers that could be borrowing money to qualify to buy that house.
And I would think right now with the way mortgage rates are and the way that building construction material costs are, that's pretty substantial.
It can be very overwhelming.
Over a rule that has affected building houses.
Correct.
Which we really don't know what the rule is.
There is some ambiguity, that's for sure.
Some ambiguity.
Yeah. And I would add.
That's putting it lightly.
Yeah, I would add, I've never met somebody.
It could be nice.
Yeah, that's anti-environmental. They want to protect the environment. They want to do the right things. I think why the WOTUS definition is so contentious is the permitting program is broken, and the cost to comply with the permitting program is excessive. And so it's almost a death sentence when you get that notice that you have a water in the United States that you have to deal with.
I'll tell you what, I want to move to Ms. Briggs just for what time's left. I understand that many Waters Advocacy Coalition members' organizations filed Freedom of Information Act requests to obtain more information on how the agencies are implementing WOTUS. What kind of response did you receive from them?
First, I just want to say that this WOTUS rule is standing in the way of affordable housing, renewable energy projects that are benefiting communities like the construction of schools, and environmentally beneficial projects like the development of wetlands. I've heard from many states that are wanting to build wetlands in order to improve water quality, but they can't get through the 404 permitting process. But to answer your question, we did get a response. Most of it was redacted, and they once again failed to provide the implementation guidance. We know it exists through the documents. We know they don't want the public to know it, but they have not handed over.
What was the reason for redacting?
They said it was deliberative, so I don't understand.
So they're still deliberating?
I don't understand why it's labeled deliberative.
But this is the guidance?
Yes.
But it's not finished, because we're deliberating.
That is what they are
It's
saying.
not classified, right? It's just deliberative.
They say it is deliberative, therefore they are still deliberating over it, but it is being used in the countryside.
Mr. Chairman, this is nothing but typical overreach from the federal government, who doesn't really care what input anybody puts in anything or what anybody says. They're going to do what they feel like they want to do and try to hide whatever they can. I would like to enter into record, if I could. This is the 1,200-page, mostly 581 pages, as a matter of fact, of redacted pages of the response from the U.S. Army Corps of Engineers on WOTUS.
Without objection, so ordered.
And I'm out of time. Mr. Chairman, I yield back. Sorry for going over.
Mr. Duarte, you're recognized.
Thank you, Mr. Chairman. Thanks, panel, for being here today. Ms. Briggs, you were from American Farm Bureau. farmers got to farm land, and sometimes we take farming land out of farm systems, maybe take wheat fields and graze them for a few years or a few decades, depending on markets and business models and the entity's desire to farm one crop or another, under one cropping system or another. So right now we're in a situation, and we're speaking today about permit processing at the Army Corps of Engineers and EPA that is almost non-existent, or at least very, very slow. The Army Corps of Engineers has also, as I understand through some consultants I work through, put notice that they're not even doing delineation verification mapping work right now. If you're a farmer and you simply have a professional biologist map the wetlands that might be jurisdictional on your land, using their best understanding of what wetlands may or may not be jurisdictional, from whatever information they can get from the Army Corps these days, which may be vague. They're not even processing those right now because they're so backed up with permits, in my opinion, greatly regulating wetlands that they have no authority to regulate. Are you getting that feedback from any of your farmers?
I'm certainly hearing it from WAC members that approved jurisdictional determinations in many core districts are just not happening. And that's really rich because when you talk to the Corps about AJDs, they say, it's a free service. Every landowner can get one. Nothing to worry about. Go down to your local Corps office, we'll hook you up with an AJD. But there are core districts out there that are not issuing AJDs. They're prioritizing AJDs that are linked to a permit. So what this is effectively doing is pushing landowners into PJDs. PJDs are basically when landowners concede that everything is, they throw their hands up and concede that everything is jurisdictional. They go through the mitigation, they go through the permitting process. It's the only way to move the process forward.
So if you don't concede jurisdiction to the Corps, they will not process your delineation maps.
In some core districts, that is correct.
Yeah. Excellent. Mr. Meserly, home builders. You want to build homes, you've got some dry rolling grasslands, as is familiar in California. It doesn't look like a wetland to anybody who is wetlands. A U.S. Geological Service doesn't map anything on the property as a wetland. But nonetheless, a home builder may need to submit a delineation that suggests that whatever features are on that property are not jurisdictional wetlands. If they don't declare them jurisdictional wetlands, they're not going to get processed. Is that an experience you're having?
Yeah, a lot of times the core districts are deferring on performing approved jurisdictional determinations, or AJDs, and encouraging applicants to fill out the PJD, the preliminary jurisdictional determination. And the problem with that is if these are isolated wetlands, they're not regulated by the Waters of the United States, you, by default, accepting the terms of the PJD is it's non-binding, it assumes everything is a water of the United States, and you cannot appeal it.
Let me skip ahead here. So farmers go to the NRCS or the Farm Service Agency to have their federal government engagement with what their farming plans are and what farm programs or restrictions may be placed on them. Home builders may go to a local zoning or a local permitting agency at the county level or state level to suffice things. Has there been any better communications with these regulatory agencies than there has been with your advocacy groups? Does the NRCS, FSA, local ag commissioner, local farm advisor, local permitting office, and local state offices have better information than you've seen as to what the Army Corps of Engineers is requiring under these new WOTUS regs? Either one. I think there's a short answer.
Well, they are not coordinating with each other, and the most perfect example of this is the understanding of prior converted cropland, because NRCS and Army Corps are now supposed to have the same understanding. The Corps has moved to a change of use policy to be in line with what NRCS is doing, but they have different interpretations of what that means. So that's impossible for a landowner to navigate.
Mr. Meserly?
Something similar, we often see farm fields apply for an AJD. They'll be told, you need to talk with NRCS. NRCS will come out and verify it.
And just to finish up here, because I'm running out, and every violation of the Clean Water Act is subject to potential criminal penalties. There's no effort being made by the Army Corps of Engineers, EPA, and sometimes DOJ gets involved here. I know that personally. And there's no definition of what's jurisdictional, and criminal penalties loom over anybody who violates whatever the Army Corps' interpretation of this law is. Is that a workable situation for your constituents?
No, it's not. And to finish it up, both agencies will point to the other agency and say, we will give you a letter that says this is what you have, but it's up to the other agency to make a final determination and determine your eligibility for farm benefits or determine your eligibility for Section 404 of the Clean Water Act. And it really puts them in a catch-22.
And we already have a U.S. Geological Survey of every mapped water of the United States to begin with. We've thoroughly mapped our waters of the United States, but that cannot be used conclusively to determine WOTUS
That's correct.
jurisdictional.
That's correct.
Thank you. Yield back, Chairman.
Mr. Ezell.
Thank you, sir. Thank you for all for being here today. And I'll tell you, over a year ago, we were here discussing the same concerns, over a year ago. And I want to thank you for coming back again, some of you that were here last year. But I want to kind of I have several things I want to try to discuss and try to get to all of it today. Ms. Pokin, how the regulatory agencies engage with your state while implementing the Sackett decisions?
Thank you. It's tough to say because I'm not sure they're implementing it. As I said, our district office for the Corps of Engineers has articulated that they don't think anything has changed in our state, but I would posit that indistinguishable should mean something, and I also think that the court's concerns around the vagueness should matter as well. I think it's unfortunate that we would have to coordinate with our Corps office and that Colorado has had to in such granular detail, when the court made pretty clear, I think, that they'd like it to be a common sense, understandable definition that your average homeowner can go out and understand whether or not they need to get a permit from the federal government or not.
Common sense don't normally go along with the federal government. My next question is for Mr. Messerly. This committee has heard from home builders and how the significant nexus test would cause great confusion for construction projects. Thankfully, the Sackett decision struck down this significant nexus test and provided more clarity on federal jurisdiction over waters. However, the administration's conforming rule only cut out the significant nexus. What are the areas of the Sackett decision that are not being implemented, and what effects are they having on home building?
It boils down to a relatively permanent water and a continuous surface connection, where there is no demarcation of where one ends and the other one begins. And they're not simply following that. It really causes a great deal of confusion for states that have regulatory programs, states that want to develop regulatory programs, because they don't know where federal regulation ends and theirs begins. So it creates problems on both sides of the aisle. I look to Ohio. We have a tiered wetland approach for permitting approach for wetlands that the state regulates that are not waters of the United States. It works very well. Our state program was implemented after the Swank decision in 2001. I would encourage you all to look at that. The tiered permitting system has distinct timelines that must be followed, and permits are issued by default. We protect every wetland in Ohio, and it works very well.
Very good. Following up, my district is a unique situation where projects may fall under 3 different Army Corps jurisdictions and subject to 3 different sets of standards. To eliminate confusion, it is incredibly important that all the Army Corps establishes clear standards across all jurisdictions. Mr. Messerly, given your experience, can you speak how different districts are implementing the Sackett decision, and how is it impacting industries across states with multiple core jurisdictions?
All districts are not created equal, unfortunately.
Yeah.
There's great differences. Some are implementing Sackett almost exactly the way the Supreme Court ruled. I'm sorry, implementing WOTUS, but when we look at some other districts, they're really floundering. They're not able to process AJDs. They're not able to process permits, and it's debilitating in those districts.
Thank you. Ms. Briggs, it was brought to my attention some Army Corps districts in Vicksburg have stopped issuing approved jurisdiction determinations altogether. What impact do you think this is having on the people in Mississippi?
Yeah, I'm glad you brought this up because Vicksburg is one of the core districts that has said they're not approving AJDs, and resources are actually being moved from Vicksburg to other core districts. So that is just going to exacerbate the problem. And you know, our builders, our farmers, our energy developers are not going to be able to take on these projects without Clean Water Act permits. And if I just may, you asked him a question about significant nexus.
Right.
And I would very much argue that the snippets that we've received through the field memos that the agencies have released, if taken collectively, fundamentally aren't that different from significant nexus. And this is what we feared as WAC. We feared that the court, they would get rid of significant nexus from the rulemaking, and then it would come up with a policy that has the same force and scope of significant nexus, but just call it something different. And that's what we think is materializing.
Thank you. Mr. Chairman, if I could have one moment.
Go ahead.
Continuing you, Ms. Briggs, I know you are here representing the Waters Advocacy Coalition, but by trade, you represent the agricultural industry. Can you speak to how this rule has impacted rural agricultural land and rural landowners like ones in my district?
Keep it to about 20 seconds.
It's confusion, it's uncertainty. The exemptions are really not providing the certainty that our members need in order to be able to use them. So.
Thank you. Mr. Chairman, I yield back.
Mr. Van Orden.
Thank you, Mr. Chairman. I'm just going to say out loud what everybody here is thinking, because it's readily apparent. No one in Washington, D.C. knows what the hell they're talking about when it comes to this subject. Zero. Last year, we had a dude with a 40-pound brain who's a law professor lecture us about how to run farms. I asked him last time he was on a farm. He said his mom, this is like, we just pulled up the transcript, his mom used to get horse manure, and they used that in his garden. And those are his bona fides. There's simply enough stupid to go around in this entire problem set. And when I agree with Mr. Larson, what's going on here, right? That's dogs and cats sleeping together at this point. So here's the problem. Congress keeps putting their fingers into things where they don't belong. They don't. You know who knows what's going on here? You do, ma'am, and my farmers do. I represent the 3rd Congressional District of the state of Wisconsin. We have the largest contiguous section of the Mississippi River in any congressional district in the country. You go from Lock 3 to 11, right? From Red Wing down to Dubuque. We don't have a north-south highway in the 3rd Congressional District. We have the Mississippi River. And we are at the forefront of not only organic farming, but also conservation. So our guys built these retention ponds, so you have runoff and all of these nutrients go into these ponds, and then they settle the bottom, they pull them out, they reuse them, it lowers input costs, they put the water that's in there to irrigate the fields again. All of that will go away. And you know where those nitrates are gonna go? Right into the Mississippi River, into the watershed, and they're gonna go down to Mike's district. That's gonna happen if this happens, because we've got a bunch of really super duper important people around here, and if you don't believe me, ask them, they'll tell you. And they're gonna tell you how your farmers, how to run their business. That's a non-starter. So here's part of the problem. Congress is lazy. Congress is lazy. My predecessors abdicated the responsibilities to the executive branch so they could keep getting elected and come up here and have these very super important meetings. That's what happened. Well, guess what happened? Chevron happened. So Congress is going to have to do their job, which is write very prescriptive legislation and tell the executive branch what they're going to do, because we are the Article I authority. We're members of a co-equal branch of government, and they've been obfuscating these things. They've been running a new Green New Deal agenda, disguising it as confusion about legislation. I can't understand this. Let's write a rule. Nope, you don't get to write law, we do. So I'm going to be here at least until January 4th, or I don't know. I'll be at least here until January 4th. We'll probably have another meeting January 5th, maybe someone else from Wisconsin, I don't know. But as long as I'm here, I'm going to do this. I'm going to advocate incredibly strongly for my farmers and yours to make sure that they can feed the world. And I don't really have a question. I'm sick and tired of talking about the same thing. I'm sick and tired of our farmers talking to me every day. They don't know what to do. They don't know if they're breaking the law. They don't know if they're going to be able to feed their families. They don't know if their house is going to be taken away from them because they're getting charged $64,000 a day for doing something that they thought was right. That is not okay. It's not. This is broken. So when I get input from my farmers, and I sit down and I listen to this cat, and Val, my buddy from Oregon, who's a Democrat, and we go like, okay, let's craft legislation to make sure this works well. When we do that, we each represent 850,000 people. That's what the executive branch is supposed to do, not run their own agenda. It's very frustrating. It is. And with that, I yield back.
The gentleman yields back. My understanding is there no other member that has desired to ask any questions. That being the case, our hearing today concludes. I want to thank our witnesses for your great testimony. It's been a very, very good hearing. A lot of great questions, and I think very beneficial, not only for each of the members here on the committee, but for those who choose to take a look at the record later. This has been an exceptional hearing, in my opinion. With that, let's see, we got any final things I need to get in the record? No, sir. All right, the bosses here say we're clear to go. Subcommittee adjourned.